Oh, wait, let's unpack this. Imagine a high-stakes legal battle, not over some groundbreaking new tech, but over whiskey.
Whiskey, yeah.
Specifically, the names and, the branding of premium spirits.
Mm-hmm.
For this deep dive, we've pulled together a recent Supreme Court ruling on, well, a major trademark dispute.
A really interesting one.
And our mission to uncover how courts assess similarity, how they view consumer behavior, and what truly defines brand identity in this kind of unique, discerning market.
What's truly fascinating here is the Supreme Court's recent decision. It involved Pernod Ricard's big whiskey brands, Blenders Pride and Imperial Blue,
Right.
and their challenge against a locally produced whiskey called London Pride.
London Pride, okay.
It's a great example of brand law in action, really.
So when this first landed, what was the immediate sort of bombshell? The Supreme Court, August 14th, they actually dismissed Pernod Ricard's plea for an interim injunction.
It did, yeah.
That might surprise some folks. What was the core reasoning there?
Well, the court really honed in on the nature of the product itself and its consumer. If we connect this to the bigger picture, they emphasize that premium, ultra premium whiskeys, the kind we're talking about.
Yeah, the expensive stuff.
Exactly. They're targeted at a highly discerning consumer base, people who know their whiskey.
Right, they're not just grabbing any bottle.
Not usually, no. The court's view was, look, when you're choosing a top-shelf spirit, it's rarely an impulse buy. You're probably exercising greater care, right?
We're looking at the label, the bottle.
Scrutinizing it. So this makes confusion far less likely, in their view. And they also pointed out the distinct trade dress, the unique packaging of London Pride.
Ah, so the look and feel were different, too.
Very different. That was highlighted as a major factor, yeah. Preventing potential mix-ups. But it's key to remember, this ruling was specifically for the interim injunction application.
Just the temporary stop order, basically.
Exactly. The main case keeps going.
Okay, but what about that shared word, pride? That seems like the sticky point. For most of us, you see two brands sharing a core word like that.
Yeah, it feels like there must be confusion, right?
Yeah. How did the court untangle that specific bit?
Well, this raises that important question. Can just one shared word be enough to block another brand? The court made a pretty crucial distinction.
Huh?
They noted pride falls under what's called public juris.
Public juris, meaning?
Meaning it's a term that's so commonly used, sort of laudatory, especially in the liquor industry. Think pride, reserve, special.
Ah, like those generic praise words.
Exactly. It's difficult for any single company to claim exclusive ownership over just that word. So its use alone couldn't be the sole basis for an injunction.
Okay.
They specifically pointed out that the dominant parts like Blenders and London are really quite distinct, visually and phonetically.
So it's about the whole picture, not just one word.
It really boils down to the overall impression, yeah.
Huh.
Not just zeroing in on one common thread.
It sounds like they went deeper than just a visual check then. If they weren't simply putting the marks side by side on a table.
No.
What was the court's actual standard for judging this deceptive similarity thing?
Right. The proper test isn't that direct comparison you might do in a supermarket aisle. It's more subtle.
How so?
It's about whether the challenged mark, London Pride in this case, viewed on its own, creates an impression of association or common origin in the mind of an average consumer, but crucially, an average consumer with imperfect recollection.
Ah, so not someone with a perfect photograph in their head.
Exactly. Think about it. You see a bottle one day, then maybe weeks later you're trying to recall it. Would that slightly fuzzy memory make you think, oh yeah, that London one must be from the same people as Blenders?
Makes sense. Your memory plays tricks.
It does, and the court basically found no deceptive similarity under that specific test.
Interesting. Now, the court also had some pretty strong words about Pernod Ricard's legal strategy itself, didn't they? Trying to combine bits from Blenders Pride and Imperial Blue to argue against London Pride.
Yeah.
That sounds creative.
Yeah, creative is one word. The court called it a hybrid and untenable pleading.
Ouch.
Untenable.
Pretty clear language, yeah. They stated very firmly that each trademark has to stand on its own and be assessed independently.
So you can't just mix and match features.
You can't cherry pick generic words or, unregistered bits from multiple different marks and sort of mash them together to build a case against a third one. It just doesn't work legally.
Got it.
And furthermore, the allegations about counterfeiting, the court found those were just speculative. No credible evidence brought forward. It really reinforces a key point in this industry, especially spirits where advertising can be restricted. Brand recognition often comes down heavily to that distinctive packaging and, deep-seated consumer loyalty.
Right. People stick with what they know and recognize on the shelf.
Precisely. So, for you, the listener, kind of diving into this with us, what's the big takeaway here? The court saw no real similarity beyond that common kind of generic word.
Pride, yeah.
Especially when you look at the different packaging, the different writing, the bottle shape, all aimed at a market segment that's pretty careful about what it buys.
That sums it up well. But, and this is vital to remember, this whole ruling was specifically about that interim injunction request.
The temporary hold.
Right. The main trial, the actual commercial suit, that's still going to proceed on its own merits. So the full story isn't quite over yet.
Okay, so still more to come, perhaps. But what does this piece of it mean for us, thinking about brands? This deep dive really shows just how nuanced, how complex brand identity is in the eyes of the law.
It really does.
Especially when you throw in specific markets, specific types of consumers.
And it raises an important question, I think, for you to consider. In today's world, just teeming with products, everyone vying for attention, how much does a single, maybe common word truly matter when the overall brand impression, the whole package, the look, the feel, and the sophistication of the person buying it are all so distinct?
Something to reflect on, maybe over a glass of your preferred beverage.
Indeed.
Until next time, keep diving deep.